I will do my best, and in a way I'm happy. I have just to comment and not try to offer a cohesive theory or explanation or even summary of what we're talking about. So I will share with you, I will comment by sharing with you things that do worry me when I have to deal with cases like these ones. First, awards are made to be enforced. To me, this is clear. And even if just for negotiations order, my negotiation power will be much stronger if I have an enforceable award. So this means that rules should be taken into consideration of other countries' of public policy, of mandatory rules, who might lead either to setting aside or impeding, prohibiting the enforcement of an award. Second issue, why do I choose arbitration? Among other things, especially when I agree on the applicable law, because I wish a more, let me put it this way, business-friendly interpretation and construction of the law. This brings me to, again, to the mandatory issues. I would make a distinction here. Mandatory issues embedded in a way on the main applicable law, and mandatory legal rules coming from neighbor areas. I will come back to this distinction. To be specific, if I choose the Greek law, I practice Greece, I'm really worried about the famous 281 Greek Greek Civil Code disposition, which has a general interdiction of exercising any law in an abusive way. It's terrible. It can lead the judge to say whatever he wishes. Can I exclude the application of 281 when I agree Greek law is unapplicable? To be discussed. Second issue, and this comes to what Anna Mandakou in a way raised, the ex officio. This is not a rule embedded in the main corpus of the law, but is a regulative aspect of the Greek law. For instance, I have a litigation, and this concerns shares, bank shares. And in the litigation, there is an issue that might have an effect on the validity of the transaction, stemming from the regulation of the bank activity in Greece. Should this be taken into consideration or not? Especially if it has not been brought up by my other colleague, and it has been mentioned by a very competent judge. Here we come to the Jura Novit Curia or not. Finally, to me it is quite important that we see that there is a risk, and that might in a certain way undermine international arbitration of, I think you used, Professor Besson used the word fraude à la loi, which means that we are trying to use arbitration to have a certain law that otherwise would not be applicable. This is also a risk to be taken into consideration. But I think I've taken enough of your time. I've shared some of my worries with you, which might be interesting for you as well to be discussed. Thank you for your attention.